table. This is an appeal in the matter of WTGIL Ltd and the Commissioners for HMRC.
Yes, Ms McCarthy, can I just ask at the outset, is there a transcript being made of the hearing or not?
No, there isn't, my lord.
Thank you, it's always good to know.
Good morning, my lord. I appear on behalf of the appellant, who I'll refer to as Ingenie, or ISL, when I'm talking about the various companies.
Yes.
And Mr Mantle appears on behalf of HMRC. You should have 3 bundles, a core bundle, a supplemental bundle, and the authorities bundle. And you should also have the parties' skeleton arguments. And please may I check, I emailed a correction to, I think it was your Lordship's clerk yesterday, in relation to the skeleton argument concerning a quote from Finland. Is that something that your Lordships have seen?
Just it was some different paragraphs.
Exactly.
Yeah.
And I don't think there's anything more that I need to say about that. And when I come onto the case, I'll obviously refer to the correct paragraphs.
May I just check another point? Because in the middle of last week, I think, a revised version, or maybe a slightly amended version of your skeleton was supplied. Can I take it that doesn't differ in any substance from the one which was previously in the bundle, which I'd already begun marking up?
Yes, I think that's correct. I think all that had happened was the authorities' references had been...
As long as it's just references.
It's just
in
references.
Substance, it's the same. That's
It's
what
exactly the same in substance,
Thank you.
my lord,
Yep.
yes. And can I also check whether the court has had a chance to pre-read the skeleton arguments and the decisions below?
Yes.
I'm grateful. So we take our skeleton argument and grounds of appeal as read, and I will adopt almost all the arguments therein. There is one argument I no longer need to make because of the common ground between the parties on this point, and that is the argument concerning the status of ISL's supply being one of goods. So you'll have seen from the skeleton, my learned friend rightly predicted that because of his understanding as well of what the Upper Tribunal decision means, I no longer need to make the goods argument. Precisely where this fits in the overall analysis, I'll flag when we come to it.
So it's common ground, it's a supply of services, the services consisting of fitting the box.
Exactly, yes. Sorry, my lord. In the phrase fitting the box, the parties agree that the Upper Tribunal is also including the provision of the box that is then fitted.
It's provided, but it's not a supply of goods.
No, but I'll explain on the relevance of why it is that I seem to be making a pedantic point when we get to it in the sequence.
Thank you.
So if I could just please start with a very high-level overview to set the scene. You'll have seen from the documents that the context of this appeal is telematics or black box insurance, and the provision and the fitting of the associated equipment, which the parties have been referring to as the device. There are 3 central parties to the arrangements at issue. There's ISL. ISL is part of the Ingenie Group. That included a company called IL, the technology company which developed the technology required for the telematics offering, and that included the software and the analytics process and so on. ISL is the customer-facing entity which provides the route to market. Because IL and ISL were in a VAT group, we're only concerned with ISL. The second central party is the insurance underwriters, and the third central party are the customers or the policyholders. And then there are 3 key contracts. There's the contract of insurance between the underwriters and the policyholders. There's also a contract between ISL and the insurers, pursuant to which ISL supplies insurance intermediary services to the underwriters. And finally, there's the contract between ISL and the policyholders, under which ISL agrees to make available to them a telematics device, to have it fitted in their car, and then to provide certain data services throughout the duration of the insurance contract. The focus of this appeal is on that third contract between ISL and the policyholders.
Contract or contracts? What about the terms of business agreement?
I'm going to come on to that in just a moment. And the central issue is whether ISL makes taxable supplies in relation to the device to policyholders under that third contract that I've just mentioned for consideration. Now, in the Upper Tribunal, ISL succeeded in proving all but one aspect. The Upper Tribunal agreed that ISL was making taxable supplies in relation to the device to policyholders, but it did not agree that they were for consideration. This was because the Upper Tribunal held that there was no direct link, in inverted commas, between the taxable device-related supply by Ingenie and the consideration given by the policyholder. Now, my Lord, as you correctly identified, there are two further contracts involving another entity called Ingenie Retail Limited, or ARL. When I get onto the contracts, I will show you both of those as well, as part of the relevant background. But we agree with the First Tier in the Upper Tribunal that those do not impact the VAT analysis, because the provision of the device-related services to policyholders is not a part of either of those agreements. So I accept it's part of the relevant background, and I'll show Your Lordship all 5 of the agreements. But as we and the First Tier in the Upper Tribunal agreed, actually the main event is what we'll refer to as Section 1 of the policy booklet.
But it is the terms of business agreement, if I got this right, is a contract not just with ARL, but also with ISL.
Yes, so the premise is ISL is introducing ARL to policyholders to provide the policyholders with certain services. But when we look at it, and it's a sort of boilerplate agreement which wasn't particularly drafted to fit precisely the relationship here, but we obviously have to interpret it. I accept that. But none of those terms impact on the core question, which is the provision of the device services, if I can refer to them as that, from ISL to the policyholders, because that is governed only by Section 1 of the policy booklet. And specifically, when you look at the TOBA, as it's been called, you'll see that that mainly refers to things that ARL will do, and it contains no promise, very distinct from Section 1 of the policy booklet. It contains no promises in relation to the provision of the device services.
Thank you.
And just if I can add one footnote to that, please. When you read the First Tier and the Upper Tribunal decisions, certainly when it comes to the Upper Tribunal decision, that's been drafted in a way that might suggest or imply we were seeking to rely on the TOBA. And the Upper Tribunal says, well, no, the TOBA is not relevant because it's not for the provision of the supplies. That wasn't actually the case. The way that the TOBA arose in the argument was HMRC introduced its relevance before the First Tier Tribunal, so a different counsel to Mr. Mantle, but they relied on it in the First Tier Tribunal to try and suggest that ISL was providing some other services, not simply the provision of the device services. And they didn't succeed in that argument. So the TOBA is not and has never been anything that we have particularly relied on in order to make any of our points good. Although, of course, I appreciate it's part of the relevant background, and we will look at it.
Can I be sure I understand why you are seeking to establish that you made taxable supply? Is it so you can recover the input tax on the cost of acquiring the kit and the services?
Essentially, yes. And my Lord, I was actually just about to come on to that, because this is part of explaining why it is I'm no longer arguing the goods argument. I also want to make clear exactly the role that data services has to play in this appeal,
Yes.
because you may have seen reference to that. So that's exactly the point that I wanted to come on to just now. So you'll have seen, and it's core bundle, tab 2, page 15, paragraph 2 of our grounds. You'll see that there was a potential preliminary matter about the nature of the supply that ISL made to policyholders, which arose, we say, but I suppose it doesn't really matter, from a potential lack of clarity in the Upper Tribunal's decision, it would appear that this has now been agreed between the parties. And if I can just explain the background to that matter before I show the court the relevant documents. So, as your lordship has already foreshadowed, this litigation arose from claims to recover overpaid VAT, and ISL made those claims to HMRC. ISL's position is that it's making taxable supplies to policyholders, therefore it should be able to recover the input VAT in relation to those supplies. So for our purposes today, that would be the cost of providing the device, the cost of the device, and the cost of the fitting services, as well as input tax arising from corresponding adjustments to its partial exemption method. Quantum and that methodology is not at all before the court today. ISL made two claims. The first one was in relation to input tax incurred on the cost of device and the associated fitting costs. HMRC refused that claim, and that refusal is the decision that is now subject to this litigation. Issues of quantum are parked. That's still before the first tier. The second claim that ISL made was in relation to input tax incurred on the cost of providing the data services. HMRC have not yet issued a decision in relation to that claim, so that claim isn't part of this appeal, which is why in a couple of places the first tier and the Upper Tribunal note that the VAT consequences of data collection and analysis are outside the scope of the appeal. So that wasn't something that it was possible for us to appeal because HMRC haven't yet made a decision in relation to it. Now, in relation to this appeal concerning input tax on the device and fitting services, the first tier considered that ISL was making taxable supplies to the policyholders of services, namely the provision and the fitting of the device, and also using it to collect data to provide information to the policyholders and insurers, but of course that second part isn't relevant to this appeal. And if I could just please show you lordships that's the core bundle 169, so core bundle, tab 11, page 169. In particular, it's paragraphs 86 and the first sentence of 87. So, in a nutshell, the first tier concludes, although this isn't a supply of goods, it doesn't mean it's not a supply of services. And then the first sentence of 87, I now consider whether there was any consideration provided for the provision and fitting of the device. So it's clear to us being both parties, that the relevant services that the first tier identified was the provision and the fitting of the device. Now, the Upper Tribunal appeared to agree with that analysis, that it wasn't goods and it was services as the first tier had found. And if I could ask your lordships please to turn to the Upper Tribunal's decision, core 7, pages 90 to 91, and paragraph 39. However, having appeared to agree with the first tier, and certainly the Upper Tribunal has never said anything to suggest that the first tier was wrong, the final sentence is, therefore, we have proceeded on the basis that any supply of services by ISL to policyholders was confined, and then these words, to the installation of the device. So on reading that, our concern was, well, do these words inadvertently narrow the finding of the first tier, notwithstanding that the Upper Tribunal certainly didn't seem to intend to narrow those words? Now, just taking a step back, before the first tier and the Upper Tribunal, we argued that the supply that ISL made to policyholders was of goods, being a fitted device, alternatively of services, being making the device available and the fitting services. Either analysis, so it doesn't matter to us which one, would bring into the scope for the deduction of input tax on the cost of the device and the cost of fitting. The only reason we made the goods argument was because it was relevant for an alternative ground that we raised below concerning deemed supplies of goods. We are no longer making that argument, so we no longer need to argue about whether it's goods or services, and we are content simply with the position that it's a taxable supply of services, provided that the services so identified are broad enough to encompass provision of the device as well as fitting. And if I can go, please, to HMRC's respondent's notice, they're very helpful confirmation that they read the Upper Tribunal decision in the same way as us in that respect. So this is Core Bundle, tab 3, page 27. And if I could ask you, Lordships, just to reread paragraphs 5 to 8, and in particular it's 6 to 8 that we're focusing on. So 5 to 8.
And the practical consequence of that is that if you succeed in the appeal, you can recover input tax both on the cost of the device and on the cost of fitting it.
Exactly, and the fitting services were charged by a third party, so we were obviously concerned that we didn't find ourselves restricted, in fact, just to the garage costs. We want to be able to have the input tax in relation to the cost of the device.
Ingenie, it's Ingenie's technology, but presumably you have a third-party manufacturer to make it.
Exactly. I think, so this is all historical, but it was called, I think, Redtail. So there are costs incurred in relation to the device, there's costs incurred in relation to the fitting services. Those were borne by Ingenie. There'll be a separate argument, no doubt, about partial exemption and quantification, but that'll be dealt with by the parties and brought back to the tribunal only if they can't agree. Yeah, so that's the position, and that's why it's particularly important for us to be clear and to find that we're not inadvertently blocked out of some of the recovery because of the way that the Upper Tribunal phrased its decision. Nothing in that decision sounds to us that it was deliberately seeking to narrow the scope of the services provided by ISL. And it appears HMRC agrees with our interpretation. And the way that HMRC have put it in paragraph 6, they say the Upper Tribunal's description of a service of the installation of the device includes both the provision of the device for the purposes of it being installed in the policyholder's car and the fitting of the device in the policyholder's car. And that is essentially what we read the Upper Tribunal to be deciding as well. So just in relation to this narrow issue about the nature of the supply from ISL to policyholders, if I can just summarise the position. Both parties agree on the interpretation of the Upper Tribunal's decision, that it includes both the provision of the device and its fitting. And so in due course through my submissions, I'm just going to call these device services or the device supply, just for ease. I'm not going to keep repeating provision and fitting, but we agree that that's what it is. You'll also see in due course that that's consistent anyway with the contracts. Because of HMRC's confirmation in their respondent's notice, for which I'm very grateful that they were upfront about this, we no longer need to rely on our supply of goods argument. So that means you can essentially put a line through paragraphs 27 and 28 of our skeleton argument, because that no longer arises. Now, we then say that the Upper Tribunal was right, that this is a would-be taxable supply, so taxable supply, if it's made for consideration. The Upper Tribunal disagrees with the HMRC disagrees with both the Upper Tribunal and with us, and considers that the supply of services by ISL to policyholders is somehow some overall exempt service. And you'll see that that is in their respondent's notice that we've just been looking at, paragraph 3. That's the first of their 2 respondent's notice arguments. I'll address this in due course.
Is it addressed in your skeleton?
No, because we didn't know that the Revenue were going to raise these points at the time we submitted our skeleton. But our essential position, until I've heard my learned friend develop his submissions, is the Upper Tribunal dealt with this very comprehensively in their decision, and we adopt the Upper Tribunal's decision. There's just one, and actually I suppose just for completeness, since we're looking at it, you'll see at paragraph 4 the Upper Tribunal does raise a second point. This actually we foreshadowed in our skeleton, and so Annex 1 dealing with Empire Stores, what would the value of consideration be if consideration was provided? So Annex 1 of our skeleton. I'll cover this as we go through, because needless to say, if I can identify that there is a direct link, and if I can also satisfy the court what the value of the consideration is, then that answers the question, can a value be placed on it? Yes, because I've satisfied the court as to what that value should be. So I will also cover both respondents' notice points in my opening. There's just one final point on ISL's supply to policyholders that I want to make clear. You'll also see at paragraph 6 of the respondent's notice, the Revenue have said, the Upper Tribunal held in clear terms that the relevant service did not include collection and analysis of the resultant data. That was correct, as data collection, as the data collection and analysis services were outside the scope of the appeal to the Upper Tribunal. I just want to make one point clear. That's not strictly accurate. It's wrong to suggest that the Upper Tribunal made some sort of positive finding that data services were not being provided. Rather, as we've already seen from paragraph 39 of the Upper Tribunal's decision, the Upper Tribunal simply said, however, we were told by the parties that the VAT consequences aren't for us. Now, that is accurate. So I don't want it to be said against us that we have somehow accepted the Upper Tribunal made some positive finding excluding data services, because that isn't the case.
Well, the paragraph does say Upper Tribunal held that the relevant service. Exactly. You don't quibble with that, do you?
If by relevant what is meant by the service that this court is concerned with, then yes, I don't quibble with that, but I didn't want it to be said later that the Upper Tribunal has somehow made some positive finding that data services were not supplied under the contract.
Because that would impact your other case.
Because that would impact the other claim, inadvertently, because this is not what this dispute is about, exactly. So, having then dealt with the preliminary issue and exactly why it matters to us and what is and isn't before this court, this then leaves the 2 questions for the court as being those identified that we identify as ground 1 and ground 2 in our grounds, which just for reference is paragraph 3, core bundle, page 16. And so our first ground is, did ISL make a taxable device-related supply to policyholders for non-monetary consideration? We say yes. Now, as I just mentioned, if we're right on ground 1, there's then a separate question that we raise in paragraph 4 of our grounds. What is the value of the non-monetary consideration? We say that's the cost of us making the supply. I rely on a case called Empire Stores, and this was referred to in our Annex 1 of our skeleton. And as I've already mentioned, that argument implicitly addresses the revenue's second respondent's notice point, which is if there's consideration, it doesn't have monetary value. Now, alternatively, if we're wrong and there's no non-monetary consideration, then the second question is whether ISL made a taxable device-related supply for monetary consideration. And we say in the alternative, yes, there was monetary consideration paid by a third party. And I want to emphasise paid by a third party because notwithstanding that our presentation was in relation to third party consideration before both tribunals, neither tribunal actually answered the third party consideration point. But if we're right on ground one, we never get to ground two. And it goes without saying, but just for completeness, if we're wrong on ground one, we're right on ground two, the monetary consideration obviously has the value of the money that we've just identified. So there isn't a separate valuation question.
So as a result of what you've told us so far, can we cross out and or goods in...
Exactly.
And can we also cross out and use?
Yes, I think we weren't intending to make a separate point when we said use. It was simply my way of trying to express the making available of the device. So we were not trying to introduce data services by the back door. So yes, feel free to put a line through use, provision and fitting.
Thank you.
So just pausing there, coming then to the order of my main submissions, I'm going to make these in 5 parts. I'm going to show you briefly the legislation. Then I'm going to move on to the contracts. Then I'm going to go on to ground one, non-monetary consideration. That submission has 5 subsections to it. So 1, the role that contracts play in VAT. 2, what are the rights and obligations as between ISL and the policyholders? That goes on to 3, our submissions on direct link. We say there is a direct link between the services supplied and the consideration provided. Our 4th subsection is the value of that non-monetary consideration. And I'm simply going to fold that into my discussion of Empire Stores. And the 5th subsection is the errors in the Upper Tribunal's decision. And you'll see we actually set this out in quite some detail in our skeleton argument already. So I'm just going to highlight the main points in that. I'm not going to read it all out again. So then back to our 4th part of our submissions. I'll then move on to ground 2, monetary consideration. And then the 5th and final part of our submissions is dealing with the revenue's first respondent's notice point, why the revenue is wrong, that the supply by ISL to policyholders should be exempt. And as I said, that should only be short because we simply rely, I don't have anything to add to the Upper Tribunal's reasoning, which we say is correct. And hopefully by the time I've taken you through the contract as well, you'll see why that is so.
There's a second respondent's notice point, which I think is it capable of monetary?
Exactly.
But that all comes within your
Empire Stores.
Empire Stores.
Exactly. So when we get on to the cases, I'm simply going to go through the European, the ECJ, the CJEU cases in chronological order, and I'll emphasise when we get to Empire Stores, because Empire Stores was a case all about whether there was consideration, and if so, what was its monetary value. And we say that there's a parallel between that case and this. And the monetary value, just so you've had the submission, on the Empire Stores footing is the cost that Ingenie incurred in providing the device and providing the fitting services. And I should say, because I equally don't want this to be something that perhaps is being thought about, you might think, well, hang on a second, if the cost on which you have to pay output tax, if that on which you have to pay output tax is the cost, and what you're getting back is input tax on the cost, why are we here? Because of the impact in relation to the partial exemption method, which is emphasised all the more so when we get on to data services, which is the second part of the claim, which is not before you. So that is in effect why we're here. It's not simply the to and fro of the output tax and the input tax directly incurred. So then if I can just go through briefly the relevant legislation, which is part one of my submissions. It's common ground that EU law remains applicable for this appeal, and that the VAT Act must be construed to conform with the Principal VAT Directive, or the PVD. So I only intend to refer to the PVD, like the tribunals below, and you'll see that the Upper Tribunal set out its explanation as to why it was only referring to the Principal VAT Directive, and that's just for your note, paragraphs 10 and 12 of the Upper Tribunal's decision. If I could ask you please just to take up the authorities bundle. And turn to page 5, so tab 1, page 5. And the relevant article is Article 2.1c. But you'll see in passing, I'll simply show you 2.1a. So Article 2.1a, the supply of goods for consideration is subject to VAT. C now is the main focus of this appeal, the supply of services for consideration by a taxable person acting as such. Just in passing, if I can show you please on page 7 of the authorities bundle, Article 14.1 sets out what is a supply of goods. Again, this isn't the central focus of our inquiry anymore, but just so you've seen it. Because if you turn now please to page 9, Article 24.1 defines a supply of services by reference to what is a supply of goods. So a supply of services shall mean any transaction which does not constitute a supply of goods. Moving on please to page 11 of the bundle. At the bottom of page 11 you'll see Article 73. In respect of the supply of goods or services, the taxable amount shall include everything which constitutes consideration, obtained or to be obtained by the supplier, in return for the supply, and then these words, from the customer or a third party. And this is the point about third party consideration. So it's not fatal to our case that a policyholder did not hand over £150 to Ingenie. We say that the third party that paid for the supply in this case was the insurer. And I'll develop that when we get on to the monetary consideration ground. And then please could I ask you to turn to PDF page 16, or sorry, bundle page 16. And Article 168A essentially is the right to recover input tax in relation to goods and services that are used for taxed onward transactions. And then moving on, please, if we can go backwards one step, please, to page 14. Article 1351A sets out the insurance exemption, insurance and reinsurance transactions, including related services performed by insurance brokers and insurance agents. Now that is expanded upon in the VAT Act, and I think that that is a central part of my learned friend's argument in relation to his first respondent's notice point, but I'll park that for the time being, because it's set out and dealt with in the Upper Tribunal's decision on the point on any view. So that's all I needed to show you in relation to the legislations. That's part one dealt with. Moving on then to part two contracts. There are two principal submissions we make on the contracts. The first is that ISL provides the device services under a direct contract between it and the policyholders, which is section 1 of the policy booklet, which I'll show you lordships in due course. And the second point is that ISL provides insurance intermediation for and behalf of the underwriters only, and only the underwriters. And that point is relevant because it addresses my learned friend's first respondent's notice point about insurance intermediation services. We accept that we do provide insurance intermediation services, but they are provided only to the underwriters. And the Upper Tribunal agreed with us that the fact that we do that does not in any way infect the nature of the services we supply separately to policyholders. What I'm proposing to do is address the relevant contractual documents chronologically, by which I mean in the order in which the different elements in the network or framework of contractual relationships would have arisen. So that means I'm going to look first of all at the agreement between ISL and the underwriters, and you'll see the agreement that the tribunals looked at below and the one we'll look at today is the CAVIA agreement. And that's agreed to be representative of all the ISL underwriter agreements. Secondly, I'll show your lordships the administration agreement between ISL and Ageas Retail Services, so ARL. And you'll see that ISL subcontracted to ARL the performance of some of its services under its agreement with the underwriters. So that's all to do with the underwriter ISL piece. Those two agreements would have been entered into prior to any policyholders coming on scene, and they are the background to then the subsequent policyholder agreements. At that point, I want to show you something that decisions referred to as the customer journey. So if you imagine the policyholders will sign up to an insurance policy online and they'll go through the various steps online. We have printed out in the bundle that the first tier referred to in its decision, the step immediately prior to the customer clicking to say, yes, please, I want to buy this policy. What you'll see is that that customer journey shows very clearly that the policyholders had access to the policy booklet, and the policy booklet contains both the contract between ISL and the policyholder in section 1, and then in section 2 it's the insurance contract between the underwriter and the policyholder. And the policyholder was also provided with what we've been referring to as the TOBA, which is the Terms of Business Agreement, which principally involves ARL and policyholders. Ingenie having introduced ARL to the policyholders, and you'll see that's an express term in the TOBA. And so if I may start off then with the first relevant agreement, which is the agreement between ISL and the underwriters. That is Core Bundle tab 14, and it starts on page 276. And just for your note, the First Tier discussed this agreement at 36 to 42 of their decision, and the Upper Tribunal discusses the agreement in paragraphs 59, sub 1 and 2 of its decision. And so you'll see from the cover sheet, Covea is the insurance underwriter, and ISL, Ingenie Services Limited, is identified as the intermediary, defined as the intermediary. Moving forward, please, to page 278 of the bundle. Clause 1.1, definitions. You'll see approved collection agent. Now, it's identified here as a body called UK AIS Limited. The First Tier recorded at paragraph 21 that it later changed its name to ARL. It's not quite correct. In fact, UK AIS transferred its assets and business to ARL, but nothing turns on that. So UK AIS, approved collection agent, is for all intents and purposes ARL. You'll then see that there's a definition for commission on the same page. The amount payable to the intermediary in relation to the sale of a policy, etc. Over the page, please, to page 280. Insurance provider, you know, that's Covea. Insured. A person who is the insured party to a policy sold following an introduction by the intermediary pursuant to this agreement. So I want to note the words pursuant to this agreement. And we say that, as we'll see when we look at the rest of the terms, ISL provides introducer services for Covea. Policy is defined as the Covea contract of insurance, in effect. You'll see premium, the total amount payable by an insured for a policy, including IPT. Products are insurance policies, so products does not mean the device or anything like that. And the products here are a reference to Covea's products. So just the only point to emphasise, as I did, product doesn't mean device. PDF 281, please, you'll see sub-agent.
But it's more than just the contract, because supplementary product is the, we see over the pages of the various services.
Exactly, there are various add-ons, but it's not, all I want to say is product isn't some sort of shorthand including the device, it's simply add-on insurance-related products, insurance, so breakdown cover, theft cover, various other add-ons. Over the page 281, sub-agent, we'll see in due course that that is ARL. And, Your Lordship, as you just pointed out, of course, supplementary products, additional types of insurance cover. Moving on then, please, to page 282, clause 3, authority. There's the express conferral of authority by Covea onto ISL, and to do all these various things for the underwriter, so on behalf of the underwriter. So entering into the products and renewing them, so on and so forth. ISL is acting on the underwriter's behalf when it does all these things, in return for the commission, as we'll see. I just want to flag the last sentence of clause 3.1, please, where it says, in particular, the intermediary is solely responsible for any advice the intermediary gives to customers. Mr. Proctor-Wilton confirmed in his evidence that ISL does not actually give advice to customers because it didn't have any qualified staff to do that, and it wasn't regulated to do that. So in fact, that language has no application. I've just realised that you don't have the transcript, but it's in the transcript of the first year. I don't think anyone's taking a point on that. The point is, in reality, that last sentence didn't have any application in the arrangements. Moving on then, please, to clause 4, the intermediary's obligations and rights. This imposes detailed obligations on ISL, in particular 4.1.1 to market and sell the policies, 4.1.5 at all times to comply with the guidance, moving down, if I may, quite a long way. So 4.3, the intermediary shall notify Cavea Insurance immediately. 4.3.13 sets out deemed agency, is a clause where ISL is deemed to be the agent of the insured, but only for a limited and specific purpose. 4.3.14 we say is relevant. It's the obligation on ISL to notify Cavea of a policyholder's breach. We say that in the context of the revenues respondent's notice argument, it's an important provision worth emphasising. It's wholly inconsistent with ISL being some sort of agent or intermediary of the policyholder, because what we're being expressly told here is that ISL has to shop the policyholder to Cavea, so to report any policyholder misconduct. And by contrast, if ISL were the agent of the policyholder, it would owe them fiduciary duties, including of undivided loyalty. And so if ISL were the policyholder's broker, clause 4.3.14 would be a breach of that. So this further illustrates that insurance intermediation ISL is doing only for the underwriter. Now moving down, please, to clause 4.4. The intermediary shall, and this sets out various clauses, various obligations, including an obligation on ISL to install or procure the instalment of the device. And you'll see here that ISL has various obligations to the insurer in respect of the device. But there's one point to note. You'll see that there is here no duty on ISL under this contract to provide the policyholders with any data or any feedback on their driving. And this will become more relevant when you see part 1 of the policyholder booklet. But if I can just step back and just explain very briefly how the telematics would operate. The policyholder has the black box fitted in their car. Data is sent to the insurer, and their premiums will go up and down according to the data and the analysis of the data. But as we'll see from part 1 of the policy booklet, the policyholder is also provided with an app and information about their driving, so that they can monitor, they can compare their driving against the data, and so they have the opportunity in order to improve their driving and reduce their premium and so on. So there's 2 lots of data provision. Data provided to the insurer, which of course this contract governs. There's also data provided to the policyholder, which this contract is completely silent on. The insurer is completely indifferent as to whether the policyholder has an app or not. And we'll see in due course the significance of this. The only obligation to provide data to policyholders and advise them on their driving emanates from the direct contract that the policyholders have with ISL, which is in section 1 of the policy booklet. Now, looking at clause 4.5 in passing, the intermediary isn't entitled to any other fee. What we'll see in due course is the device fee is already included as a component of the commission. So ISL isn't entitled to any other fee. 4.6, various warranties ISL gives to the underwriter in relation to device. And 4.7.
So I just go back to 4.5.
Yes.
Does that mean should not be entitled to charge the policyholder anything? Or does it simply, as between ISL and the insurer, that's the totality of the remuneration?
Yes, I actually hadn't thought about it that way, but actually I think your lordship's reading is probably correct, and I possibly put clause 4.5 too high. No, I think actually your lordship's reading is right, and I was wrong. Yes, so that is simply saying ISL can't charge Cavia anything other than that which is set out. Yes, I think that must be right. I'm not sure anything turns on it, but I think rereading that clause, I think that's probably correct. I was on clause 4.7 then.
Can I just see whether that is or isn't right? I mean, this is in return for performing any of its obligations under clause 4.4, which, perhaps most importantly for our purposes, includes at 4.4.1 providing and installing the device. And it may be important for it, meant it, from the insurer's point of view, for the scheme to work as a whole, that if it's going to be provided with a device amount as part of the commission, ISL isn't going to charge or also for that service, and indeed the other services, which might discourage assureds from taking out the insurance.
So sorry, I think your lordship was testing the point the other way, if I understood it, by asking whether or not that also precludes ISL charging the
yes, it would make some commercial sense for the insurers to want to insist upon ISL not charging the customer any more than it was receiving via its commission, which included a device amount, because otherwise that might discourage assureds from entering into the policy.
So what you'll see in due course is that as a matter of fact, ISL as a matter of fact, the TOBA that we'll look at in due course sets out certain fees that ISL or ARL, depending on who is meant by the relevant term we, may charge to the policyholders.
But those aren't, are they, for any of the services in 4.4?
Well, some of them are, but I would say that in fact the evidence was that no additional fees, so the relevant wording in the TOBA was may. The evidence was that in fact no additional fees were charged. Everything was done by way of mechanically adjustment of the premium. So say, for example, the policyholder has the device fitted in their car, and within 1 month decides it's going to cancel. It's paid up front in advance, the whole year's premium. Within 1 month it decides it's going to cancel. We'll see from the terms in due course, the proportion of the premium is refunded, save for an amount equal to the device amount. So everything that ISL gets, it is paid via the insurer, and mechanically it's adjustments to the premium, notwithstanding that certain things aren't proportionate adjustments. There is this lump sum called the device amount.
Right. But we also see, don't we, in the second part of the policy wording, which is that between the policyholder and the insurer, a promise that the cost to the policyholder will be nil. Isn't that where we find that promise? And the insurer can only make that promise if it's also secured the agreement of ISL not to charge for it.
Yes, that's correct.
Which might suggest that 4.5 is intended to be where one finds that undertaking on the part of ISL. It may not matter very much. I'm just intrigued by.
Can I just have
Yes,
1
do.
minute
Yes, do.
to... Sorry, it may be that I need to discuss something over the short adjournment, but I think also, well, if I can put it this way,
It may not matter. Come back on that.
given
if
that
you'd like to.
I think all the parties in the tribunals below were proceeding on the basis as I first attempted to explain clause 4.5, I don't think it matters to the overall VAT analysis whether clause 4.5 is preventing ISL from charging anything more, or is to policyholders, or is simply preventing ISL from charging anything more to the underwriters.
Thank you.
I was going to then move on to, we looked at clause 4.6 briefly. Clause 4.7, compare and contrast the relationship between ISL and its customers versus all the other obligations that it's owing to Cavia under this contract. It's very diluted. It's simply to have regard to the interests of the customers and treat them fairly. Moving on then, please, to clause 5, page 285. Clause 5 deals with claims, notifying them to Cavia. That isn't relevant to this case. Then clause 8 on page 287 sets out the premium. If I can note in particular clause 8.5, payment to ISL shall be deemed to be payment to Cavia. As we'll see, it's in fact handled through the agency of the approved collection agent, which is ARL. So ISL, or in reality its agent ARL, plainly receives the premium for and on behalf of Cavia. And it goes on, repayment shall be made by ISL on behalf of Cavia, but it shan't be treated as having been made until it's actually received by the policyholder. So again, this shows clearly that ISL isn't the agent of the policyholder, because if it were, then receipt of the payment by ISL would constitute receipt by the policyholder. And then 8.10, emphasising that money held by ISL is held on Cavia's behalf. 8.14, ISL shall pay Cavia the premium after deducting its commission. Clause 9, commission. Cavia agrees to pay remuneration to ISL. So ISL's entitlement to commission is as against Cavia. Again, we say confirming that they're Cavia's agent, acting on Cavia's behalf. And you'll see that the commission comprises two distinct elements. £150 for each policy sold to an insured who does not have a working telematics device already fitted. So we say, in effect, that means it's £150 per box. You will see that sometimes, because some of the documents date from different periods, sometimes it's 150, sometimes it's 165, but that's the gist of the amount. That's what we've been calling the device amount. And then 9.1.2, 10% of the premium net of IPT. We've given a worked example in terms of the money flows at paragraph 67 of our skeleton.
That had £100, 10% commission and £1,000 net premium. And I wondered if that was correct, because I thought 10% was 10% of the gross premium.
I'll check that over the short adjournment.
It probably doesn't make any difference at all.
I don't think it makes any difference to the analysis, but I will check that over the short adjournment. 9.2, the trigger for the commission falling due is the collection of the premium by ISL from the insured. And 9.3, if among other things the policy is cancelled, ISL will return the 10%, but it retains the device amount. And so pausing there, if the policyholder already has a device fitted, its overall premium will be 150 less than if it didn't have a device fitted. Essentially, if ISL provides a device, ISL's commission is £150 more. If the policy is cancelled, the device, as we'll see from part 1 of the policy booklet, remains in the policyholder's car, becomes the property of the policyholder, and 150 is deducted from any amount of premium that a policyholder who paid all up front will get back. So there's always a link between what we've termed the device amount and a policyholder having or not having a device. Not relevant at all for ground 1, that becomes relevant when we come on to talk about monetary consideration, but I thought I'd make the point since we were looking at the relevant clause.
So does that mean that if the policyholder keeps the same car and renews the policy next year, the policy is cheaper, or just that you get less commission?
No, the policyholder is not charged 150. Yes, so cheaper, assuming it's like for like. I appreciate that it may not be cheaper in real terms, but yes. Cheaper than if it was a new policyholder with all features the same. That new policyholder who doesn't have a device would pay 150. The one who does wouldn't. This was in Proctor Wilton's evidence. It's possible sometimes that someone has a working device, they cease their insurance, a couple of years later they come back. Ingenie will try and get the device working again, and if they do, they're not charged the device fee. Or sorry, their premium is 150 less than it would otherwise be.
And is that something that the policyholder, is that transparent to the policyholder? They're told if you've already got a device, you pay 150 less, or is it just you tick a box saying I've already got a device and the quote comes out at less?
In terms of the customer journey, I will need to take instructions on that because that wasn't something that we looked at. I'll need to check that.
Okay.
So I think we just looked at clause 9.3. Yes, if the policy is cancelled or among other things, ISL repays the 10% but retains the device amount, and the device at that point will remain in the policyholder's car. Clause 10 deals with the sub-agent, in particular approval of sub-delegation to the approved collection agent, and that's the genesis of, we'll see, the agreement between ISL and ARL. And then clause 26, so if I could ask you please just to go to 298. Clause 26 is potentially important or relevant. Unsurprisingly, third parties have no rights under the 1999 Act. So unsurprisingly, the policyholders have no right to enforce any terms of this agreement, and the policyholders under this agreement have no right to enforce ISL's obligation to Kavia in relation to the device or its fitting.
I'm sorry, which clause are we looking at?
Clause 26.
Starts on 297, in fact.
Oh, sorry, yes, you're quite right, sorry, my apologies. Starts on 297 over the page to 298.
Thank you.
So pausing there just to draw the threads together, we can see under this agreement, ISL is expressly appointed as Kavia's agent to put into place and to administer policies of insurance on Kavia's behalf. In doing so, it's subject to numerous important obligations to Kavia. In return for its acting as agent, ISL is entitled to be paid remuneration by Kavia, so the commission. And certain aspects of this agreement are wholly inconsistent with ISL acting as an insurance intermediary of the policyholder. So the next agreement in the framework that I'd like to go to, please briefly, is what's called the Third Party Administrator Agreement between ISL and ARL. And you'll find that in the supplemental bundle. And it's tab 9, page 200. And as I've already mentioned, UK AIS is, for these intents and purposes, ARL, and it's an agreement between ARL and ISL. Just for your note, the first tier dealt with this at 43 to 46 of its decision, and the Upper Tribunal at 59 sub 3 of its decision. I can deal with this agreement more briefly. So if I could ask you please just to go to 211, clause 3.1. You'll see that ISL appoints ARL to perform the AIS services. Those are set out in Schedule 1. If I can please ask you to go to page 237. And so you'll see that this covers things like quote and buy, call centre. Sorry, if we just scroll down, pre-sale is the quote and buy, call centre. Point of sale, 1.1 on page 238, to commit the insurers to the policies. And so we say that that's the exercise of ISL's authority under its agreement with Cavia. You'll see 2.1 deals with the premium payments, and then just turning the pages, certain obligations post-sale on page 239. Page 242, you can see that ARL can sell various add-on products. Again, that's nothing to do with the device. 243 deals with renewals. 243, bottom of 243 also deals with payments. And so the mechanics of it is the insurers will receive the net premium, which for your note is defined on page 207. ISL will receive its revenue share, defined on page 209, plus telematics box fitting costs. There's no definition of that. And ARL, AIS, retains its revenue share. Again, that's defined on 209. Moving forward, please, to page 247. 247 sets out ISL's services, so marketing the product, managing the panel of insurers, managing the telematics box fitting process.
Sorry, where have we gone now?
I'm sorry, page 247, Schedule 3.
Who is the client?
The client is ISL.
ISL.
And so 1.15 through to 1.17. So it's all what the client, so ISL, will do. And they're elaborated on in the following parts of, in the later parts of the schedule.
This may not matter. For some reason, the copy I have got, going by the pagination, goes straight from 246 to 255.
That 246 to 255. That might be because you do actually have some pages missing. I'm sorry.
Yes, I've got those in my bundle. So.
You have, I see, so maybe it
looks-
sounds as though America's got some missing,
Pages.
not got those pages. In which case, if they could be provided over the adjournment, that would be...
Yes, my lord, please can I just check which pages you're missing?
Yes, I go from 246 to 255, so I'm presumably missing 247 to 254 inclusive.
Thank you. We'll provide those over short adjournment. My apologies.
Thank you very much.
And I've already mentioned, we don't need to go to them particularly, but the defined terms for commission, gross premium, net premium. Now, Schedule 5 has, which is on 251, which I appreciate, my lord, you're actually missing.
Yeah.
That sets out how the commission should be split. And it's essentially 90% to ISL, 10% to ARL. And then you're also missing, unfortunately, page 254, which is a worked example, and you can see that the device fee, well, unfortunately, Your Lordship can't see, but the device fee is split out on page 254, the worked example. So we'll make sure we definitely provide those over the short adjournment.
Thank you.
And that does have a commission of 100 and a net premium of 900, as opposed to your...
Yes,
skeleton.
I think the figures in my skeleton are wrong in that respect. So just standing back, in essence, the agreement between ISL and ARL is that it's putting into effect the agreements between ISL and CAVIA pursuant to the express permission to delegate that was contained in the CAVIA agreement that we've seen. And the important point is that we say this consolidates the role of ISL as providing insurance intermediary services on behalf of the insurers. It's showing that as a matter of practical reality, ISL is providing those services through the agency of ARL. So that concludes what I wanted to say about that contract. The next document that I just want to show you, Your Lordships, is what's been referred to as the customer journey, which is the point on the website application process where the policy booklet and the TOBA are introduced to policyholders. So if I could ask Your Lordships, please, just to go to what the First Tier Tribunal, the findings the First Tier Tribunal makes about this. So this is Core 11, page 158, and it's First Tier Decision 24 to 26. And if I could invite Your Lordships first, please, to read 24 to 26, then I'll show you, Your Lordships, the corresponding documents. And so the corresponding document, so the customer journey, is in the supplemental bundle, tab 15, page 309 to 314. And so we're picking this up at the point at which the customer is now being shown the cheapest premium, and you can see that if the policyholder drives well, they can earn discounts. And you can see on page 309 in the middle, the driving is reviewed 3 times a year. And then just scrolling through the customer journey, you'll see there are various optional items such as windscreen cover, breakdown assistance. And then at the end of the customer journey, which for our purposes is the bottom of 312 over to 313, the driver's shown how much they had to pay in total if they paid the premium in full or by instalments. So you'll see right at the bottom of 312, check your payment and policy summary, your payment. Over the page 313, the table at the top gives the alternatives depending on whether it's instalments or upfront. Now, just looking at the various other documents on this page, that so this is before the point of sale, the policyholder can click through to. You'll see just above the words "your policy," view terms and conditions. Now, we think that that's the terms and conditions of the financing. I don't think these T's and C's have ever been before the tribunal. They're not relevant, but that makes sense in the customer journey, so we'll just ignore those. Then it sets out the summary of your policy and the summary of this particular driver. And then you'll see that there are 3 other links to click through. View the policy wording, and that is the policy booklet that I'll show you in a moment. Please read our terms of business agreement, that's the TOBA. And then the last thing, the insurance product information document isn't relevant to the appeal, it's just the boilerplate required documentation, but that doesn't contain any further terms and conditions that we need to concern ourselves with. So the sequence of events is that in particular section 1 of the policy booklet is made available to the policyholder prior to his entry into the insurance contract. So if he's got his quote, he then has access to what it is that ISL and separately the insurer will do for him, which we'll see in the policy booklet, before he makes his decision to go ahead and buy the policy and pay the premium.
If I understood correctly, it's never actually sent to him. That's only ever available on the website.
Let me just check. I'm pretty sure it is subsequently sent to him, but let me just double check. Yes, it is subsequently sent to him as well. So
it's not attached to the welcome letter.
Yes, sorry, it's part of the pack that comes with the welcome letter.
Is that right? That doesn't look like it to me from the welcome letter. If we look at behind tab 11, we've got the welcome letter, and at 285, at the top of it, it has the summary of the details and says, don't forget to check through the summary of your policy details of the documents we've included with this letter, and they're then identified at the bottom, which is a cover note, statement of insurance, demands and needs, and the terms of business. So TOBA gets sent. And then it says your policy wording contains important information, and you can read or download it from the website. And I think Mr. Proctor-Wilson's witness statement only ever refers to it being available on the website rather than it being sent. But if I'm wrong on that, please show me otherwise. But it didn't look to me as though it's a document which is ever actually sent to the.
Let me double check that over the short adjournment, if I may. 1 minute. Thank you, my lord.
Thank you.
I suppose from my perspective, the real point that I wanted to make of importance is that the policyholder is provided with the policy booklet before he takes out the policy itself.
Well, access to it.
Access to it, yes.
Under the view of the policy wording,
Yes.
which an insured might think, if they haven't got it, it's simply going to be the terms that apply between the policyholder and the insurer. That's what policy wording usually contains.
Well, I think what I would say is it can't be relevant to our analysis whether or not the policyholder, what assumptions an individual will make, whether they'll actually click through or not. I mean, I suspect 99% of policyholders never read any terms and conditions. But that doesn't mean that the terms and conditions don't govern their arrangement just because the policyholder's chosen to ignore them.
So you can enter into a contract without knowing you're doing so.
Well,
I mean, as far as the policyholder is concerned, what they think they're doing is buying insurance from an insurer, and that's what they are buying.
well,
Your analysis is, yes, they're entering into that contract with the underwriters, but they're also entering into a separate contract with you.
because that is the wording of the policy booklet, which they are provided before they enter into their contract.
Well, as my lord said, provided the possibility of accessing if they click through, which most people don't.
Well, if I could put it another way, there will come a point where subjectively a policyholder has to take some interest in this because they're also not told the details about when the box will be fitted and so on. So I appreciate the reality is that policyholders might not click through, might not read the full terms and conditions, just as some policyholders may never read all of the terms of the insurance contract, but that doesn't mean that those terms don't govern their relationship, whether or not a policyholder has chosen to look at them and what the policyholder assumes or chooses to read or not.
But it may go a little bit further than that, because what they're offered are the policy wording and our terms of business. And they might think, well, if I want to know what governs my relationship, not with the insurer, but with Ingenie, it's our terms of business that I need to click.
But I think I think, my lord, the important point is that well, the documents are all provided and are there for the policyholder. You may well have policyholders that click neither. You may well have policyholders that click and read both. And the VAT analysis can't change between whether you've got a policyholder that wants to read all the documents before they click on pay and proceed versus a policyholder that reads nothing. And whether or not our terms of business might suggest that these are terms as between ISL and exclusive terms between ISL. The reality is if the policyholder were to go through to the policy wording, they'll be presented with something that is very clearly setting out, as we'll go on to see, that there are two separate contracts.
Yes, I think you have the benefit in this case of HMRC not taking issue with there being a legal relationship giving rise to an enforceable obligation as between Ingenie and the policyholder. All I'm putting on marker is that from a consumer contract point of view, that may be an assumption we need to make for the purposes of this case, which isn't necessarily, or obviously so to me.
Well, the other point that I would make, as we've seen, is that the customer, as you'd imagine with all businesses, there is an evolution in terms of clarity, what the website looks like, so on and so forth. These have all been taken to be representative of the whole position, but neither the tribunals below nor HMRC has made any sort of suggestion of, because of the label of the hyperlink, this somehow affects the legal relationship.
Right.
Moving on then to the policy documents themselves, we say that's the key booklet. It's the booklet that you would see if you clicked through to the car insurance policy wording. It's in the core bundle, and it's tab 13, page 216. This is the 2015 version. There were two other versions, but again, with immaterial differences, this is taken to be representative of all of them. And again, just for your Lordship's note, that's discussed First Tier decision 47 to 57, Upper Tribunal decision 59, 4 through to 10.
Sorry, could you give me the UT reference again?
59 sub 4 through
Thank
to
you.
sub 10. So the first point that you'll see is that as we go through this, the policy booklet's divided into two distinct sections, as the First Tier recorded at 32 of its decision. The first section occupies pages 218 to 219, and it's headed Introduction to Ingenie. And the second section is everything from page 220 onwards, appearing after the words contract of insurance. So our position, which the First Tier and the Upper Tribunal didn't disagree with, is that this first section contains or evidences a direct contract for the supply of services between ISL and the policyholder, pursuant to which ISL provides the device, device fitting, and also, as we'll see, data services. And by contrast, the second section evidences the contract of insurance between the insurer and the policyholder, and ISL is not a party to that. And we say that that's not just the natural and proper construction of the documents. Objectively speaking, it's clearly the intention of the parties. So if we can then please look at detail in the first section, which starts page 218. It opens with what we say are critical words. For this section only, this contract is between you, i.e. the policyholder, and ISL. And I want to emphasise the word contract, and I'll come back to the relevance of this later. But then this section sets out in clear and direct language the various things that ISL is agreeing with the policyholder to do. So you have provision of the device and installation in the car. So you can see halfway down the first column, an Ingenie device will be installed in the car. And then under the subheading Ingenie device, Ingenie will arrange for a device to be fitted in the car. You have the collection and the use of the data, so that's the second column under the heading telematics data. The telematics data that Ingenie collects from your Ingenie device includes. You have the promise that Ingenie will provide the policyholder with feedback on their driving. So that's halfway down the first column. The latest in-car telematics technology is used to assess your driving style. Ingenie gives you feedback on how you drive on the website or via a free mobile phone app. And then the bottom of that column, you then receive feedback on how you're driving. And Ingenie will also promises to provide driving data to the insurer. That's on the second column, under the subheading how Ingenie uses your data. Ingenie will pass the telematics data from your Ingenie device to your insurer to help them manage your insurance. On top of that, over the page, you'll see immediately under the subheading looking after your Ingenie device, it sets out that the property in the black box passes to the policyholder when the insurance expires or is cancelled. And then underneath that, the sentence beginning Ingenie will not be responsible. That stipulation allocates responsibility for faults or damage to the black box. And then finally, you'll note right at the end, this is the end of the Ingenie section of this policy, making it clear that what follows is the insurance contract, a distinct contract between the policyholder and the insurer. So what we have here in section 1 is an agreement, explicitly described at the beginning as the contract between ISL and the policyholder, and that agreement sets out in express terms the various things that the various things that will or must be done by ISL concerning the black box, the fitting of the black box, and the data services. So then turning to the second section, the contract of insurance, from page 220 onwards. And you'll see immediately under introduction, that sets out the various things that are part of the policy. Second column, third paragraph, the policy is a contract between you and us in this sense is defined as the insurer, which we'll see over the page. And then immediately under that paragraph, in return for you paying or agreeing to pay the premium, we will provide cover. The definitions are on page 222. And 222 again starts, this is your insurance policy, it is a contract of insurance between you and us. There's a definition of Ingenie, there's a definition of the Ingenie device. And you'll see at the bottom of the definition of driver behaviour, the telematics data will be used by us to determine driver behaviour. And then over the page, second column, you'll see we, us, our insurer means the insurance company, can also mean Ingenie when in relation to the device, data, etc. And then page 227, your Ingenie device. This section sets out the charges in relation to the Ingenie device. And so you'll see under subheading cost of the device and its fitting, there's no charge for the first device provided that there's no cancellation. If the policy is cancelled within the first 12 months, then you'll need to pay 165 to contribute towards the cost of the device. We reserve the right to deduct this from any premium refund due. And 165 is the equivalent of the 150 that we saw in the older Cavia contract. You'll then see a couple of paragraphs further down, if you change your car, so this has been termed a COV event or a change of vehicle event. It's £75 for the first time you change. And that increases depending on how many times you change your vehicle. And then time scale of fitting, top of the second column, this sets out an obligation on the policyholder to have a device fitted within 10 days. But relevantly, in no way is there any obligation on the insurer either to provide the device or to arrange the fitting.
Well, that's implicit in all this, isn't it? This is all part of the contract between the policyholder and the insurer, and all this envisages that the policyholder will be entitled, as against the insurer, to have it fitted initially for free, and then with the various provisions for change of event and so on.
Well, we say that the contract for the provision of the device and the fitting is as between ISL and the policyholder, which is in section 1.
Well, I quite understand you say it's to be found there, but is it not also to be found here?
Well, whether or not it's implicit in the contract between the insurer, well, can I take it a step back? The insurer doesn't own any of the IP, the insurer doesn't have any control over the device. The device, the fitting, and all of those services are being done by ISL, not by the insurer.
Yes, the insurer has contracted, as we've seen, with ISL, that ISL will do this.
Yes, and excluded third parties from relying on that contract.
Yes. So, but this is everything from 220 onwards is contractual as between the policyholder and the insurer, is that right?
From 220 onwards, yes, that's correct.
And is it not express or necessarily implied in all the parts of this that you've been showing us about the fitting of the Ingenie device that the policyholder is entitled, as against the insurer, to have the device fitted?
So we would
free.
say not entitled as against the insurer, but entitled as against ISL. So if I can perhaps put the point in a couple of ways. The obligation there is on the policyholder to get the device fitted.
In the next paragraph, the selected installer will fit the Ingenie device at a mutually convenient time. Is that not promised by the insurer that our selected installer will do it for you?
Well, we would say that's something that the policyholder has rights as against ISL emanating from the first part of the contract.
Well, suppose that ISL said to the policyholder, quite apart from your premium, we're going to charge you £200 to install this device. I don't think there's anything in the first part of the policy that stops them doing so.
I'm sorry, if ISL says that it's going to charge £200 for the device, well...
What is there in part 1 of the document, which is the contract between the policyholder and ISL, that prevents ISL from charging?
But there's simply no provision for ISL to charge fees at all.
No. It doesn't say you'll get it for free.
That's why we say that looked at in the sequence.
It's an agreement. Sorry to interrupt you. It's an agreement to provide a service. It doesn't follow that the service doesn't have to be paid for.
But that, my lord, if I may say, is precisely why we say the consideration, bearing in mind the sequence of events and when this policy booklet is presented to the customer, the sequence of events is these are the things that we shall do for you, section 1. These are the things that we shall do for you. Implicit in all of that is this is your contract in the event that you click through the customer journey and you proceed to take out your insurance contract. So you, policyholder, have provided consideration by entering to us, ISL, by entering into the insurance contract. That is exactly what gives life to section 1 of the policy booklet.
I understand that, but isn't what they're getting is a policy of insurance under which the insurer agrees that the device will be fitted at no cost.
Well,
that seems to be what the parts that we've been looking at so far of the insurance policy say.
Well, I'd say two things to that. The first response to that is our focus is on section 1, and so we need to ascertain that in return for the policyholder entering into the contract of insurance, ISL then there are enforceable obligations on ISL to provide those various things.
Yes, I understand that, and I'm not suggesting that what I'm putting to you
No,
necessarily affects the outcome
No.
of your argument, but I am just testing whether the policy between the policyholder and the insurer also contains terms that the device will be fitted.
Well, I suppose my starting point is that doesn't detract from our core case.
Right.
We also acknowledge that Ingenie owes obligations to the insurer to do those things, but that equally doesn't detract from our core proposition.
Yeah.
So
the point I'm putting to you is that the insurer owes obligations to the policyholder to do those things, because that's what this part of the policy wording. I know there's a lot more of it, but that's what this is all about.
Well, I think our starting point is no, because that arises from section 1 of the booklet. Once the policyholder has got obligations, enforceable obligations for these things to be fitted, it doesn't matter that it's from ISL or from the insurer. The other point that we would make is that certainly when you look at, and I appreciate data services isn't part of this appeal, but just testing some of the other elements, there's nothing in here that makes the insurer in any way responsible for providing data to the policyholder of their driving. But that is a key part of what the policyholder will want. The policyholder out of the data services wants two things. Wants data to be communicated to the insurer, and the insurer can't be responsible for the obligation of data being conveyed to it. The policyholder also wants to be able to assess how he's getting on in terms of his driving through his app. The app isn't a nothing, the app is important because that helps the driver understand how it is they can better reduce their premiums. And the only clause at all that deals with the app is to be found in section 1 of the booklet, not least because, as we've already seen in the ISL insurer contract, there is no obligation on ISL at all to provide the app to the driver. So ISL has not agreed with the insurer that it will do that. The only place that is to be found is in the first contract, is in the first part of the contract. So I think, taking a step back, the only matter that we need to prove in order to get where we need to be on our appeal is whether or not there is a contract for consideration under section 1 of the booklet, under which, in return for consideration provided by the policyholder, ISL has agreed to do various things. And I'll develop my submissions in due course, but we say there can be no doubt that that is a contract and consideration has been provided by the policyholder in actually entering into the insurance contract. I'll develop why it is that it's important that the policyholder has various rights and enforceable rights as against Ingenie ISL. There can still be a supply for consideration as between ISL and the policyholder, regardless of whether ISL also owes duties concerning the box to the insurer. And we would also say, regardless of whatever it is that it may be said the insurer has agreed or not agreed to do under its part of the contract. Under the second part of the contract, the one thing the insurer cannot have agreed to do, because it simply has no means of enforcing this, is in relation to the data services through the app. That can only come through the first part of the contract.
Well, it agrees to collect the data.
It may agree to collect the data, but
It doesn't agree. I'm just looking quickly at 228 and 229,
well,
which deals with the data collection. But
I
think you're right in saying that it may agree to the data collection, but it doesn't. The insurer doesn't agree to make it available to the
the insurer also can't agree that the data that it collects from Ingenie, or doesn't agree, will be accurate. So Ingenie could provide incorrect data to the insurer. The insurer will say to the policyholder, well, I've done what I was required to do. I've acted properly on the data that I've received. I've increased your premium because that is what the data I received told me. I've done my part of the contract. It can't be right to say that the policyholder can say to the insurer, well, hang on a second, that data was wrong, and I have rights as against you, the insurer, because the data that you received was wrong, not least because the insurer has no means of knowing where they are.
Well, you may be right about that, but if you look at 228, what the insurer promises in the middle of the right-hand side is that the Ingenie device will measure and transmit various aspects of how the car is driven. If what is being measured and transmitted is not an accurate aspect of how the car is driven, that would seem to me to be a breach of that by the insurer. But I'm taking you slightly off your course. It may not necessarily matter. And I entirely accept your point that there's certainly some part of the earlier part of the policy wording in terms of making it available to the policyholder, which we don't see reflected here.
And what I would also say is, if we go back to the definition of we us insurer, that means the insurance company, so this is page 223, we us can also mean Ingenie where there is a reference to the Ingenie device or the telematics data. So I would say that to the extent, this is page 223, second column, to the extent that anything is being done or promised or warranted in relation to the telematics device and the Ingenie data, that is a reference to something that Ingenie is doing, not a reference to something that the insurer is doing.
Right.
But taking a couple of steps,
taking you out of your turn, I'm sorry.
Taking a couple of steps back, even if there may be some promises that the insurer is implied as making, or makes, or however you want to interpret the terms, as between the insurer and the policyholder, that does not negate section 1 of the policy booklet. And that actually is the critical point that I must make clear.
I understand.
229 is terms in relation to how the telematics affect the premium. And then 230 is cooling off period and cancellation terms. 231 is the summary of fitting charges. And then 232 to 255 are further details in relation to policy that aren't relevant to this appeal. So that's the end of the policy booklet. The TOBA then, the Terms of Business Agreement between ISL, ARL and the policyholder. This is the last part in the framework of the agreements. It's at tab 15 in the core bundle, page 305. What I intend to do is to take you through the typed up version at 310. 305 is illegible. So 310, this was a document that we typed up for the First Tier at their request, and both parties are happy that it's an accurate document. So you can see from the top, we, us and our mean ARL and or ISL. And then here in the introductory words, Ingenie Services Limited introduces you to ARL, who will arrange and administer your insurance policy. So under this agreement, ISL's role is limited. It's solely that of introducing the policyholder to ARL. And in practical terms, it's ARL who will actually arrange and administer the insurance. And in this context, you'll see the definition was ARL and or ISL. And so whether or not it's both or one or the other depends on the context of the terms. And we say that in context, that means that where the provision is concerned in this document with matters affecting the arrangement or administration, the we is a reference to ARL alone, because that is the role that has been identified right at the top. And then page 311, you'll see there are certain fees that ARL may charge. Over the page to 312, bottom of 312, again, certain fees may apply to cover or contribute to various costs.
So you say these, none of these are matters that are contractual between ISL and the policyholder?
Yes, so ISL would not, for example, be charging directly a further £150 fee for a device.
Yeah, but what about a fee of £45 if you miss an arranged black box fitting?
I'll need to take instructions on exactly what happened in reality in relation to fees such as that. I think, sorry, and the reason, my lord, we haven't been focusing on that is because that wouldn't be something that would be within the scope of that anyway if it's a pure cancellation fee. So that's not something that the parties have been particularly concerned to identify exactly who and how that fee would be paid.
But this is a document which does seem to involve a number of charges that we don't see catered for elsewhere in relation to the services of providing and fitting the box, including, in the first place, £45 if you miss an arranged black box fitting without giving us at least 24 hours notice. £45 if we can't or decide not to fit the box because the car's modified in any way or parked in an unsuitable location.
So I think I'll take instructions in relation to precisely whether in real life these fees were ever charged, and if so, how mechanically that worked, because what I'm not sure is whether or not that was through some sort of adjustment in the premium or whether that was a separate charge. But the reason we haven't been concerned about those is because whoever they were charged by and for whatever they were charged for, they're not part of the relevant consideration in return to the supplies that we're concerned with. So that wouldn't have any relevance to our VAT appeal.
When we looked at the first contract, the terms of business between ISL and the insurer, you made a point of showing that us that ISL was appointed as the insurer's agent.
Yes.
This document starts off by saying we are an intermediary acting on your behalf, offering products and services from insurers to meet your requirements. Is that of any significance, relevance?
No, we don't think it's of any relevance. We think that if anything, it's in relation to, it's predominantly in relation to what ARL will do. So, for example, if we just look at some of the fees, a fee of £10 to issue you with a duplicate insurance document, that is a matter between ARL and the policyholder at the end of the day. That's not something that ISL or the underwriter are concerned with. Those purely administrative matters. And so, if anything, this document gives ARL a basis of charging fees like that. It is correct that certain of these other fees were included, but that was simply, and I think Mr. Proctor-Wilton deals with this in his witness statement, that was simply to make sure that whichever contract, whichever way, if the policy was cancelled or if the vehicle was changed, somehow there would be a means of getting, for example, £75 from a policyholder. Whether it be through an increase in the premium, whether it be under this document. In reality, his evidence was that ISL never issued separate charges under this document.
I remember that, but in relation, for example, to missing an appointment, so that the fitter had to go back a second time, this appears to be an entitlement to charge £45 for it, and presumably, well, you'll take instructions, presumably that's what happened.
I will do. I'm so sorry. Okay, so my instructions are that ARL would collect that fee, for example, and pay it directly to ISL. I was shown passages in Mr. Proctor-Wilton's witness statement that dealt with the COV.
Yes,
but my instructions were that the same would happen in practice in relation to the missed fitting appointment. So I don't think that's anywhere in the evidence. It's just that's what my instructions were just now.
And this is where we find the policyholder's obligation to pay that sum.
Yes,
nowhere else.
I think there's nowhere else. Yes. So relevantly, though, the TOBA says nothing about the provision of the device, the installation of the device, or the data supplies. So in this document, there's nothing that a policyholder can divine in terms of any rights in relation to have a device fitted, so on and so forth, because this document simply isn't intending to deal with that, albeit there are certain charges that may be charged depending on the circumstances. So our position throughout has been that the TOBA doesn't affect the relevant contractual analysis that we're concerned with, and the First Tier and the Upper Tribunal agreed with that. So the First Tier's agreement is at 79, the Upper Tribunal's agreement is at 117 to 119. And in particular, we would say nothing in the TOBA affects the fact that ISL's role is as agent of the insurers, as we've already seen from the Kavia agreement. So just pausing there, just to summarise what the contracts show at a high level before I get into the cases and the details, we say it's implicit from the arrangement, in particular when you look at where the policy booklet is introduced to the customer as part of the customer journey before they click on buy, that if the policyholder goes ahead and enters into the insurance contract, ISL in return will do what they promise in their contract with him in Section 1. And that's critical for us, because for reasons that still escape me, neither the First Tier nor the Upper Tribunal agreed with that proposition, but we say it's inescapable from these order of events and the promises in Section 1. In particular, when Section 1 is headed up, this contract, the word contract, especially in a consumer context, should be given some meaning. And if it's to be given some meaning, as in if it is accepted that that document is a contract, and that those various obligations are enforceable as against ISL, that can only be because the policyholder has given something of value in return. And we say when you look at the sequence of events, the policyholder is not told, in order to get this, you must pay Ingenie £100. The sequence of events is, you enter into this, we will do this for you. And that promise is of something that is of value to Ingenie because it's how ISL makes its money, as we've already seen through the commission it is paying. In particular, you'll have seen that both the First Tier and the Upper Tribunal make a great play on the absence of express terms. So we never quite got to the bottom of this, but there's simply no way to interpret the position other than, here is our offer from us ISL to you per section 1, you policyholder per section 1 of the policy booklet. If you conclude the insurance contract, in return we will do what we have promised in section 1. We say those are the relevant rights and obligations, and we say that there is relevant reciprocity. The policyholder has done something of value for ISL in return for ISL's device supplies to him. And that doesn't matter whether or not ISL has also made a separate promise under the Kavir agreement, and it doesn't matter to what extent the insurer may or may not be under implied terms vis-a-vis the policyholder. If I can just go briefly, please, to Upper Tribunal paragraph 22.1, which is core tab 7, page 87. And this really seems to be the nub of the First Tier's findings, which we know the Upper Tribunal agreed with.
So sorry, could you just give me that reference again?
22 sub 1.
Thank you.
And what I'm really interested in, because this is essentially the nub of why both tribunals found against us, is from the words while in principle, which are halfway down 22 sub 1. So while in principle there could be non-monetary consideration, if the policyholders actually entered into the insurance policy and or agreed to allow ISL to install the device in return for the device services, on a proper construction of the contractual arrangements, they did not do so. This is obviously expanded on in the Upper Tribunal's reasoning, but that really is the heart of where we're at with this. And we say that having now shown you the documents and explained the customer journey, that conclusion is unsustainable on the way in which Section 1 should be interpreted. So that concludes the documents I wanted to show you. And now I'm going to move on to the third part of my submissions, which is our first ground. The policyholder gives non-monetary consideration in return for ISL's device supplies to him under Section 1 of the agreement. Just by way of reminder, I'm going to group the submissions under 5 subheadings, and the first one was the role that contracts play in VAT. Because you'll also have seen that there was some discussion about English contractual interpretation versus consideration for VAT purposes, and we say that ultimately that none of that actually sheds any light on what the right answer should be. The right answer actually we should have ascertained by the submissions I've already made looking at Section 1 of the document and how this arises in the customer journey. And I will take you through cases on direct link, and I will take you through cases on contractual interpretation. But if I may say, those cases seem to have really overcomplicated the position in the First Tier and the Tribunal's minds, because it's as simple as that, which I've just explained. So the role contracts play in VAT. Secret hotels too. The Supreme Court in this case addresses this point. I appreciate this may be familiar, but I'm just going to turn it up briefly if I may. This is Authorities Bundle, tab 21, please. Starts at page 418. So very broadly, the case concerned whether travel agents were acting solely as intermediaries within the meaning of Article 306 of the Principal VAT Directive. If I could ask you please just to turn to paragraphs 22 to 23 and read 22 and 23 to yourselves, please. So the application here, the words for consideration are obviously to be given its EU law meaning, but the contracts are have to be construed by reference to English law in order to identify the parties' rights and obligations. Over the page, please, to paragraph 30. Who supplies what to whom is to be determined by reference to all the circumstances. And then 31 onwards sets out the correct approach in domestic law. So at 31, the contract is the starting point in order to identify the parties' respective rights and obligations. Then at 32, the court must have regard to the words used, the provisions of the agreement as a whole, the surrounding circumstances, and then this, and to commercial common sense. And one of our criticisms of the Upper Tribunal was it failed to have regard to the surrounding circumstances and commercial common sense, and it was too bound by the express words that they thought were absent from the page but somehow necessary. And then you'll see in the quote at 32, we interpret the contract to identify the parties' rights and obligations, and the last sentence of that quote, that the labels are not conclusive. 34 then sets out the correct approach. You start off with interpreting the contract as a matter of English law. You look then to see as if economic reality should lead you to a different answer. And the result of that characterisation, you then apply the relevant VAT provisions. And then if I could ask your lordships just to turn up paragraph 53. At the last sentence in 53, just under little b, as explained above, the characterisation of the relationship is a matter of English law, to which you then go on and apply the relevant VAT provision. So pausing there, moving on then to my second subsection under this heading, what are the rights and obligations as between ISL and policyholders? That is the focus of our inquiry. The rights and obligations, as I've discussed, are identified as a matter of English contractual construction. So we're looking here for what is the bargain, what is the quid pro quo, and we'll see in due course that those are also phrases used in the VAT context. And so yes, it's true that VAT isn't concerned with matters such as English law enforceability, but nonetheless, whether something is in return for, whether it's part of the, what is the bargain, is it the quid pro quo? All of these are common as between both English contractual law and the VAT position in terms of working out whether or not there's been consideration. That there isn't some extremely scientific way of analysing whether something is consideration for that means it's completely foreign to us as English lawyers.
Is this really a part of your submission that the tribunal has got overcomplicated at this point? Because ultimately, you say construe it in accordance with the ordinary rules of construction when it applies to a commercial contract to see what the starting point is. And if the starting point is you're getting a quid pro quo under an English contract, it would be pretty surprising if that didn't also fall within the relevant EU concept.
Exactly.
Although obviously it is a different concept.
Exactly.
But may well end up having much the same content.
Exactly. And so to take a simple example, if I buy something off an Amazon website, I'm told it's £10, I click buy, I pay £10 via my credit card, I expect to get my item in the mail, I've paid my consideration as a matter of English law. We don't need a very detailed examination of whether or not there's a direct and immediate link. It's obvious that there is. The difference here is the policyholder wasn't paying £10 to ISL. The step that it undertook was to enter into the insurance contract. As a result of that, all the obligations under Section 1 became live. And I think if I may just add at this point, my Lord, I think that the reason why I was making my submission that actually whether or not there may be enforceable rights under Section 2, where we are is it's common ground by the parties, between the parties, both the First Tier and the Upper Tribunal have agreed that the supplies of the device services are being made from ISL to policyholders. And for that, we're just concerned about the supply. And then the only other question is there consideration for a supply? So whether or not, and maybe this is a way in which English contract law is concerned about different things, whether or not the insurers might also owe obligations does not in any way turn that into a supply of the device services from the insurers to the policyholders. So I think that's where I was coming from when I was making the point, well, whether or not there are obligations, it's not relevant to the VAT analysis because we're concerned only here with who has made the supply of those device services. The only candidate can be ISL. And indeed, we've got findings and it's common ground that that is who the supply is emanating from. And the only question we then have to ask is whether or not those policyholders gave consideration. And other contractual obligations do not alter the fact that it is a supply from ISL of the device services to the policyholders. Whether or not the insurers have some sort of input or obligation in relation to that supply doesn't matter for that. I think that was really the point that I was trying to grapple with in answer to your Lordship's earlier question. So we've set out at paragraph 47 in our skeleton argument what we say is really the nub of what's going on here. So that's core bundle at tab 4, page 44. And if I could just make one correction to this, because I think I may have unnecessarily caused some confusion. I say the interpretation, in fact, of the tripartite agreement. What I really meant here was arrangement. I'm not trying to suggest there's now one contract between all three people involved. They're not. They're two separate contracts. Between the policyholder, ISL, and the insurer. The point about this is no one has ever told us that this is somehow wrong. As a matter of both contractual obligations and reality, what's going on, the agreement between ISL and the policyholder is, if and only if the policyholder enters into the insurance contract, does ISL then go on and supply the device services.
Yes, I'm not sure why you need the first sentence of that paragraph at all, really.
Well, no,
This is what you say, the effect of the agreement in Part 1 as between ISL
yes.
and the policyholder is.
Yes. And then it's only because ISL will do these things that the policyholder entered into an insurance contract. Now, I actually don't need little b, so I'm happy to put a line through little b. What I actually need and what we have is A, that's the core, that's the relevant reciprocity. if and only if the policyholder enters into the insurance contract, does ISL supply those things? That's it. That's the reciprocity.
But there's obviously no obligation on the policyholder to take out this policy at all. So
No, exactly.
it's a unilateral contract, isn't it?
Well, and that doesn't make it any less consideration. This is why I make the point about if I buy something off Amazon. So I buy something off Amazon, I pay over my £10. I'm not obliged to buy anything from Amazon, but clearly my £10 is consideration from that which I've bought.
Yes, but that's a different situation because there's only one contract between you and Amazon. The point here is there's two contracts. The policyholder takes out a contract with the insurer, pays the premium. That's one contract. If they do that, then you will fit the box, and that's the second contract.
And that is the relevant reciprocity, and that's all we need. Yes. Yes. So it doesn't matter that the policyholder isn't obliged to take out insurance in the first place. The policyholder has a free choice. The relevant reciprocity is because you have done this, we are now on the hook to provide our services, to keep up our end of the bargain. Needless to say, we've spent time scouring the authorities to see if there's a case that's directly on point. There isn't, but we say that's because, well, there's thorn in the VAT Tribunal that I'll come on to, but we say that's because it's a pretty elementary question. Of course something has been done in return. And in our case, on our facts, it is something of value to ISL.
I understand. That's why you say only A is necessary. I mean, if B were also necessary, then that would be infected with the question as to whether the insurers have agreed to install.
And it's as a result of our discussion. I'm not going to try and force home B because actually B isn't necessary, and our discussion has just shown that in fact the court may have doubts about the relevance may have doubts about exactly who owes obligations in relation to the totality of the device, the obligations in relation to provision of the device and so on. So I don't need B anyway. All I need to establish is A, but A is a matter of common sense.
Well, to go back to basics, as far as English law is concerned, it's if you walk to York, I'll give you £100. You're not under any obligation to walk to York. But when you do so, that is consideration for the £100.
Exactly. And this is all that I need to ascertain, which is the relevant mutuality and the relevant reciprocity for VAT. VAT does not view that as something different.
And when we look at the Upper Tribunal's reasoning, some of it at least, possibly its critical reasoning, looked at whether the policyholder was undertaking some obligation to do something in Part 1 of the policy booklet, which you say this isn't consideration in the form of a promise to do something, it's a unilateral contract kind of doing something as the consideration for a promise if you do it.
Yes.
Well, that's very clear as a matter of English law. We're all very familiar with that type of unilateral contract. What you need to persuade us, I think, is that the same is true of the requirement in VAT law, but there'd be reciprocal, there'd be something reciprocal.
Well, as we'll see from the Upper Tribunal's reasoning, direct link and reciprocity is the beginning and the end of the for consideration test, so far as we're concerned. That is the matter that we lost on. The way that the Upper Tribunal described it is reciprocity is part of direct link. What I would say in a really straightforward case such as this, reciprocity and direct link, it's the beginning and the end. That's.
And really, you say that's inherent in your proposition little a anyway.
Yes.
I mean,
there's no other way of identifying the agreement. There's no other way of interpreting what has gone on.
Yeah.
This isn't a case where we are relying on some niche proposition of English law to get us over the line in relation to consideration. The reason we say there is consideration is because there is a bargain, there is something in return, there is a quid pro quo. All of these are words that we will see in due course in the cases in relation to VAT and direct link. And indeed, part of that test is reciprocity and mutuality. And so this essentially is why we're here having this argument. Because the First Tier and the Upper Tribunal thought that something more was needed, but they have not been able to point to what more that might be, other than this notion of, well, there were no express words. Well, there don't have to be express words on the page. not least because we're told you start off by looking through a domestic law lens in order to identify the parties' rights and obligations. Once you've identified the parties' rights and obligations, then we go to the back question.
Yes. So that I don't forget it, and you may want to come back to it, the way it was formulated in paragraph 47 seemed to me to reflect almost exactly the way the point was put in Gemenda and Finanzamt at paragraph 36. The two services are mutually dependent on each other. That is to say, one is made only on condition that the other is also made, and vice versa.
Yes.
Well, and the vice versa may mean that you need B, not just A.
Well,
Do come back to that because you're not yet on. You're not yet on to the authorities on reciprocity and so on. But I just thought I'd just, while we're on your paragraph 47, I thought I'd just flag that for you.
the most simple way of dealing with the vice versa is if you, the policyholder, enter into the contract of insurance, we are then on the hook to provide the services in section 1. We are only going to provide the services in section 1 if you enter into the insurance contract. We're not sending you a black box through the mail for nothing. That's it. That's the vice versa.
But from the policyholder's point of view, if I enter into the policy of insurance, will I get the black box? The answer is yes, but that's not necessarily because you've promised it to me. If the insurer has also promised it to me, that's why B may or may not be.
B then, so in circumstances where we have banked, because even now the revenue has agreed with the proposition that the supply of the device services is being made by ISL to the policyholder, I don't mind whether the insurer might have an obligation to ensure that it is done. That doesn't affect the supply analysis.
I quite understand it doesn't affect the supply analysis, but in terms of reciprocity or mutuality, it might then be said, well, that's looking at it from your point of view, you only agree to supply if the contract is insurance is entered into and not if it isn't. But if you look at the performance of the service by the policyholder, which is the other side, and look at it from that point of view, that may be said to be in return for the promise by the insurer to provide those services, to provide the device services, not the promise by you. I'm not saying that's right. I'm just flagging this so that you may want to come back to it.
So there are 2 points to that. One is at this point we're really interested in supply rather than merely promise, and the supply has been ascertained under section 1 of the policy booklet. So it's not merely who has promised. For that, we're really concentrating on the supply. And the second point, and I wasn't planning on going to this, but it is in our bundle, and I'll take the court to this after the short adjournment. It's perfectly possible to have 2 supplies for the same consideration. So there is nothing wrong for that with ISL will supply the device services. Insurer is obliged to make sure that that's done, if that's the way that you want to term it. That could be a supply, but we're not concerned about that. But this doesn't detract from the fact that there is a supply from ISL to the policyholder, and what it is that ISL is promising is set out in clear terms in section 1. Whether or not there are also promises from the insurer to make sure it is done doesn't detract from the supply in section 1. And I do emphasise that this also isn't a point in dispute between the parties anymore because of the findings of the First Tier and the Upper Tribunal. It's not a respondent's notice point. In fact, it's been accepted. I will touch very briefly then just on 2 VAT cases, just to make the point good that there's no magic in VAT about words on the page. The first was in our skeleton. It's British Airports Authorities, tab 10, PDF page 214. I'm sorry, I got that wrong. 241, and the passage in question was at page 245, between little c and little d. And this case was about the nature of a supply that was made between the authority to a retailer in terms of being able to occupy a shop and sell goods. The question was to be determined as a matter of substance and reality. I think that's a valuable way of putting the question. The court is under an obligation to look at the substance of the agreement and to reach a conclusion as to its nature, quite irrespective of the form or the language in which the agreement is embodied. And then the second VAT case is more recent. It's Craft Carnival, which is Authorities tab 22, starts at page 437. And what was happening in this case is it concerned an organiser of fairs who was selling to exhibitors or providing exhibitors with pitches in return for money. And the organiser wanted to say that that was an exempt supply of land, but HMRC's position was that it was an overall taxable supply because the organiser was also obliged to organise a fair. The first tier said, well, I'm looking at the contract, I don't see clause 1, the organiser is obliged to provide a fair, therefore it's a supply for a bare patch of land. And you'll see from the way in which the case was decided by the Upper Tribunal, the Upper Tribunal in effect said, well, it's an implied term that the organiser has to organise a craft fair, and it's a matter of commercial common sense. And the Upper Tribunal adopted and applied English contract law principles and then applied the VAT to the resulting rights and obligations. And so if I can ask you just to look briefly at paragraphs 23 to 26. What you'll see here is then the application of familiar domestic law principles of interpretation. So that's at 24, the investors' compensation scheme. And the point that emanates from setting out all these principles is implied terms are relevant, commercial common sense is relevant. And then 35 to 40, 35 onwards under the subheading the contract sets out the parties' respective arguments, what the first tier decided. And at 37 you'll see that the first tier apparently was entitled to find, according to the Taxpayers' Council, that the organiser hadn't assumed any obligation to organise the fair. But the tribunal's decision is that overall, when looking at the contract, there was plainly an implied obligation for the fair to be organised. And you can see that from 38 and at 39, and G, commercial common sense is relevant, 39G. And then you'll see at 40, the reference to the show in the terms and conditions does not, as the first tier thought, merely set out the context. And the investors' compensation principle was applied. If I may, very briefly before the short adjournment, I just wanted then to look very briefly at the position and the principles from an English contract law perspective, but I don't think that this is necessarily, in light of some of the comments, the questions from the bench, this is necessarily something I want to spend much time on. So if I can simply indicate, we've included in the authorities bundle chitty on collateral contracts, authorities tab 28, and I would invite the court please to read pages 550 and 554 of the bundle. So 550 will see consideration and remedies and then third parties. And then 554 of the bundle, in particular 21009 and 21011, consideration in a collateral contract. The first authority that I wanted to take the court to was Open Work, which is a judgment of this court, PDF page 228. So that's tab 9, starts on PDF page 228. And that case concerned whether a clawback provision was valid, where its detailed terms were incomplete.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
And the passages that I wanted to ask the court to take...
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
The passages I had in mind were paragraphs 24 to 30, which set out principles that I have no doubt will be familiar to the court.
Sorry, this is in open work, is it?
In open work, paragraphs 24 through to 30. And the only reason for showing you this was to deal with the Upper Tribunal's analysis that it might be said to be one way that the Upper Tribunal analysed the position was that the quid pro quo was too uncertain from the face of the insurance contract. But we say that when you pay attention to the principles of construction that are set out in open work that derive from the cases, the fact that there's nothing written on the page is no bar to interpreting the existence of the quid pro quo. And just before we break, it would be convenient if I could also just please flag Charnock and Liverpool, which I suspect again is a familiar case to the court. Authorities tab 6, page 151. This was the case setting out the proposition that a car owner had no contract against the garage in circumstances where the insurer was going to pay for repairs to his car, and so had no recourse against the garage when the garage was unduly late in undertaking repair work. Answer no, there was a contract. And if I may, just before we do break, flag the two passages that I'd like to, your lordships, just to take into consideration. It's PDF page, please, 158, between G and H. There was a clear contract to be inferred from the facts. The consideration was the car owner leaving the car with the garage for repair. And then 160D to H. So a contract and the respective rights and obligations, including as to consideration, can be inferred, which we say is the right way of analysing the position here. And if that's a convenient moment to break the short agenda.
Yes. Have you discussed with Mr. Mantle the division of time between the two of you?
So I think, given that I've spent the time going through all the documents as well, I had hoped, subject to questions on any view, to be done by the end of the day. And if that's the case, then I think there's ample time. And I think that was probably what we've been anticipating.
Yes, my lord. I can finish tomorrow with ample time for my learned friend to reply if I start first thing tomorrow morning. But we'll see where we get to, obviously.
Good. Well, one's often heard this optimism, but that would be ideal. 2 o'clock.
Thank you.
Court rises.